From time to time, people say to me, Joe, can you talk to X about this thing with their channel? My response is always the same. Not my circus, not my monkeys. This show, however, viewers' discretion, is my circus. These are my monkeys. They are exceedingly well trained at throwing their feces. That is likely the very reason you have been told countless times. Okay, I didn't mean to say that. I didn't realize what that thing said. If I knew what that was going to say, I would not have thrown that up there. I feel terrible. I haven't seen that in a couple of years, and I certainly would never ever have used that as an intro. First and foremost, for Vince Major over here, who's making his debut, and I'm implying, God forbid, something about something about him, or about Chugi, or the legendary. I can't believe I'm actually on a stream with this guy, Ron Coleman. Welcome back, my friends. How are you?
My pleasure. My pleasure to be here.
Yeah.
Thanks for making the stream early enough for old people to participate.
That was the thought process. that was the thought process that the boomers should, at least be able to catch the first couple of minutes before they doze off. And,
well, you had to pick it at a time where my cat has the zoomies, didn't you? You just had to.
Well, that was obviously part of the plan. That was part of the plan. Anyhow, tonight's show. So those of you who missed last night, shame on you. But we had a phenomenal reading from two guests who joined in with me and reading May 16th from the Trump trial, which was day 2 of cross-examination of Michael Cohen, and it closed with a flourish. I'm actually condensing that into a video that which is appropriate for you to share with your friends. So, and that should be coming out tomorrow, where there was a revelation that this phone call, which was a critical phone call that Michael Cohen purportedly had with the man himself, with the boss man, Donald Trump, wherein he told him, hey, the payment got made to Stormy Daniels, that apparently he's not really sure he actually was on the phone with Donald Trump. He may have been on the phone with Keith Schiller. And, oh, yeah, by the way, he forgot to mention to the jury that the reason he was calling at that particular time is because he'd been reaching out to Keith Schiller for certain help with a crank call that he'd been getting during the previous couple of days. And that the text message right beforehand was Keith Schiller saying, all right, call me to sort this out. And he spent a total of 98 seconds on the phone. And supposedly he tried to fix it up at the end by saying, well, I think we talked about both of that during the 98 seconds. Perhaps, maybe with Donald Trump, not really sure. That's the testimony we got from admitted perjurer Michael Cohen when it was a Perry Mason moment there in the trial. And that's what the jury went to lunch with on Thursday. We ran out of time yesterday, which is why I ended up saying we're going to cut it here. And there's really, that was 150 pages we went through yesterday. Tonight's only 80 pages. So we should be able to have some fun with it without feeling pressure to rush through. And I'm really looking forward to it. Now, I am going to give my guest of honor here, Ron Coleman, first dibs on the role that you want. I would recommend, I've been enjoying playing the role of Todd Blanche the last couple of days, and I feel almost guilty that I've been stealing that honor, and I will happily defer that to you.
I'll take it. Sure.
All right.
I'm here.
So you'll play the role.
I put on my pinstripes. Okay.
There you go. You go.
My virtual background for the courtroom.
So I'll have you play Todd Blanche. If one of you have a particular inkling, I'm fine with playing Michael Cohen, but I don't need to. So my question is, if any of you have an inkling as far as you want to play some dude and throw your best Jersey accent out there doing Michael Cohen, God bless you. Otherwise, just, raise your hand if you have a particular thought as to what you want. We could do it by gender because the attorney the prosecutor is a female. So we have one woman here. So if we can do it the more natural way, Chugi, do you want to play the prosecutor? You have a push.
I mean, sure. I could give the prosecutor a whirl.
All right. So you got the prosecutor, and Vince, I'm going to ask you: would you rather play Judge Merchan, or would you rather play the role of Michael Cohen?
Oh, I am perfectly happy as the Honorable Judge Merchan.
All right. So I'm going to sit in as Michael Cohen. We're going to start this thing up here. And the transcript is actually over here. I want to make sure first and foremost you guys can see it. You can see it. Everything good, or do I need to send you private? Link?
I can see it okay. Just don't scroll too fast or you'll lose me.
No, don't worry. I try and like. Do you want me to send you a link for like? I'm just trying to figure out how I can do that. I can probably send you a link if that's easier for you. Tell me what you want.
I think
Whoa.
you can put it in there and I'll see how it goes. If I need to, I'll open it.
You knew. I'm sorry. One more time. What was that? I had something pop up on me. My audio.
Sorry. I was just saying. I mean, go ahead and put it in the private chat because people were asking about it in the private chat.
Okay. All right. I can probably do that. I got
a if we need it, it's there.
Right. I had a Dropbox link that was sent to me, which is where I got it, so I can forward that on here. I guess I'll do it that way. And that way you can all. Hopefully this will work if I do this. Control C. And I'll just throw it in the private chat. So there's a link there. Does that work for you guys, or is it exclusively for me? I never know with Dropbox.
Works fine.
I was able to open it.
Looking good.
All right, great.
So it's there if I need it. So that's good.
So we're starting though, just so you're aware, if you're on the Dropbox, at page 151, because that's where the lunch break is. So that's where you want to scroll on down to there. I guess technically 152 is where we're at. So and on the page, it's 3900 on the transcript page.
Okay, so we're doing page 3900.
3900 is where we're starting. We're starting with Mr. Blanche. This is everyone returning back from lunch.
I'm going to do it off the screen. Too complicated.
That's what I figured. It's probably easier just.
All right, tell me when we're in session.
And action.
Just briefly, we have a curative instruction drafted by the people regarding the unsealing of the existence of the indictment. My intention was to rehabilitate the questions right out of the box after lunch. If you want to take a look at that.
Let me take a look at that. So let's see how it goes with you. If it looks like it needs to be cleaned up some more, I will read the instructions.
Mr. Steinglass is the prosecutor co-counsel, so I'll just read that quickly. Very respectfully, the only relevance of this entire line of questioning was to suggest that there was an improper leak of evidence. They used the word leak. You sustained it. They used it once without being sustained and once with being sustained, some kind of improper leak. 2, that Michael Cohen or Jeremy Rosenberg or both engaged in this conduct. There's no other reason to ask those questions. And respectfully, this is not something that should be cleaned up by the person who asked the questions or on redirect. This should be cured by the court. The court has given numerous limiting instructions in real time at the defendant's request. You made this application at the morning break. It still hasn't been cleaned up. To be honest with you, I don't think cleaning it up by the parties is the right way to go. I think Your Honor ought to clarify the record and eliminate any suggestion that there was some kind of impropriety. I think those questions were entirely improper. I think it should be up to the court to cure it, not Mr. Blanche.
Judge, there are texts between Mr. Cohen and the detective where it's clearly
What?
Where it's clear the news of the indictment had leaked. Your Honor had sustained the objections around that. The questions were not asked out of the blue. There was a very good faith basis for the questions. Indeed, the detective said they told the New York Times before they told you. Nevertheless, it's done. I wasn't trying to do anything other than elicit the fact, which is entirely appropriate, that a detective assigned to this case thought it appropriate to tell a witness it was done. You sustained the objection, Your Honor. I'm happy to clean it up. It shouldn't be an instruction from the court to assume that there was something improper about the question. There is evidence that it happened.
There's nothing improper about the question, except that we now know that you left the jury with the mistaken impression. I appreciate the record you are making, Mr. Steinglass. I take instructions from the bench to the jury very seriously, so I weigh that heavily before I decide to do it. I'm going to give Mr. Blanche the opportunity to do it himself. If I'm not satisfied, what he has done fairly and completely cleans up the issue, I will take care of it.
The last point I will make, that's fine. I don't know if the witness knows that the order was issued by the court unsealing the fact of the indictment on March 30th.
I realize that. That's why I'm keeping my options open. I might have to give the limiting instruction.
Thank you.
Separately, I've been informed one of the juries apparently has a 1:30 appointment next Thursday. I have not yet spoken to that juror. I would like to take it up with that juror in the robing room during the break. I would like to invite one juror from each side to join me in the robing room with the court reporter so we can discuss it further. All right, let's get the witness. Good afternoon, Mr. Cohen. Please be seated.
Case on trial continued. All jurors are present and properly seated.
Mr. Blanche.
May I continue?
Yes.
Good afternoon, Mr. Cohen. In the beginning of the day today, do you remember I showed you some text messages between you and Detective Rosenberg?
I do.
Now, I want to make sure there's no confusion. You don't have any evidence that anybody at the district attorney's office improperly leaked or even leaked at all the indictment before it was unsealed, do you?
No.
We were talking about dates, and just to go back to that time a little over a year ago, you know that around March 30th, or actually on March 30th, the court unsealed the indictment, so it was then part of the public record, right?
Correct.
So to the extent that I asked you questions about what you learned or heard from Detective Rosenberg about the indictment by March 30th, it was public and unsealed, correct?
Correct.
Please approach. That was good, but you have to take it a step further. At the time he appeared on CNN and spoke about it, it was already unsealed.
All right. Just a couple more questions about that, Mr. Cohen. I also asked you questions about appearing on television on that day, right?
You did.
And just to be clear, when you did those interviews, the indictment was unsealed by the court, correct?
I had read it through the New York Times article.
But beyond that, if I suggested to you that you were not supposed to talk about it on CNN, I want to make sure you understand by the time you went on CNN, it was public.
Correct.
Your Honor, before lunch, we had offered B166 without redactions. We now have redactions.
Thank you.
If we can put up with B165 just for the witness, the court, and the parties.
I actually have that.
Mr. Cohen.
I actually have that. Let me pull that up here so people can actually look at it. Well, you won't be able to look at it. You
Well,
won't be able
okay.
to see it. If we do it that way, you won't be able to see it, right? Because he'll be blocking you, blocking your screen. But just so everyone can just see B165 here. This is B165. Let's see if it's bigger. So we'll see if there's any particular thing that they want him to pull up. But let's go forward.
Because you know what, actually, I can read it from Google now if you want.
Whatever. What should I keep it up there?
Yeah, I think
Okay.
so.
All right, fine. So I'll do that.
Okay.
No, I don't have it. Let me make sure I have mine.
What page are we on?
We're on page. This should be.
Objection. Okay, got it. 165. Okay. Mr. Cohen, you're looking at what we talked about before lunch, which is a series of messages between you and an unknown who says they're 14. Yes?
Oh, I'm sorry. I got everything screwed up here. I tried doing this. I tried doing it the way you suggested, and that was a great suggestion. But all right, so yeah. So you hold on a second. You asked me if they said they were 14. Yes.
The difference now is we applied redactions, correct?
Correct.
Now the number that you are communicating with is 0594. The rest is redacted.
Oh, hold on. Let me do this this way. I'm gonna give me one more second. I'll do this. I just gave you all the links, so why don't I just click that link and then have it here on the side?
And I'm sorry, crew. I'm having trouble loading that Drive doc, so I can't pull that up separately right now.
Okay. So you're saying I'm blocking your view? Is that what you're trying to say?
Yeah, that's what I'm trying to say.
Okay, give me 1 second. I'll make sure to pull that out of your way before you have to talk. Is that okay?
Okay, yeah, that's fine. Thank you.
Sure. All right. So
Mr. Cohen, you are
that is correct. So no,
that is correct. We offer B165.
No objection. Oh my god.
The court's. This is not going to work this way. I can't leave it up here. All right, go ahead. No, it's on you.
Accepted.
Just very quickly, if we can blow up the first 4 or 5 texts back and forth. So these are the texts that we talked about before lunch, where this 0594 probably mistakenly forgot to block their number at some point. Can you read what they said to you and what you said back?
This number has just been sent to Secret Service for your ongoing and continuous harassment to both my cell as well as to the organization's main line.
That was at 7:10. At 7:11, we answer back. He says, "It wasn't me."
That's correct.
At 7:11, he says, "My friend told me to call," correct?
Correct.
3 minutes later, an apology. Sorry for this.
Yes, sir.
A further apology. I won't do it again. What do you say at 7:15? If we can focus on that part of the text exchange.
Which, in case you're wondering, it's right over. It's this part over here of this. You will need to explain this to Secret Service as we've been receiving dozens of these harassing calls over the past 3 days. If you're a minor, I suggest you notify your parent or guardian.
Then the response back a few minutes later, 1 minute later, "I didn't do it," in all caps. Then another one, "I'm 14. Another one, "Please don't do this." Then, as you testified earlier, if we can go down to the 7:17 text, what do you say back?
Please have your parent or guardian contact me before Secret Service reaches out to them. What a dick. Complete.
I have to wonder if somewhere there's some, probably now 15, 16-year-old kid that's going, holy fuck, they're reading this in court.
So just so when you testified earlier, that last message back to this 0594 number, that was at 7:24 and 50 seconds, correct?
Correct.
You testified on Monday. What I'd like to do, Mr. Cohen, is going through it in a timely fashion, what you testified about on Monday. I want to start in 2011. You said you came across a poll that suggested that President Trump might be a good candidate for president, correct?
That's correct.
I just want to make sure we're on the same page. That poll was actually in 2010, late 2000s?
Yes, sir.
And there was some press coverage about it at the time, correct?
Yes, sir.
You testified that you caused a website to be created, Should Trump Run, right?
.com.
.com. And that was put up in November of 2010. Does that sound right?
Correct.
At that time, is it fair to say that the press regarded this as a little bit of a stunt by President Trump?
Yes, sir.
And a little bit later on, in March of 2011, isn't it true that the National Enquirer actually ran an article about this issue and about how strong President Trump looked in the polls?
Yes, sir.
You actually worked with the National Enquirer to help get that story out, correct?
Yes, sir.
This was in 2011.
Correct.
And the National Enquirer actually wrote a positive story about you personally at that time as being the person who started ShouldTrumpRun.com, right?
That's correct.
You were the source or one of the sources for that story, right?
Yeah. Yes, sir.
And the reason for the question is you worked very hard, putting aside what happened in 2015 and 2016. You worked very hard during your time working for the Trump Organization to get positive stories into the press about President Trump and all the things he was doing, right?
That's correct.
You also worked very hard to make sure that there were positive stories about you at times as well, right?
Yes, sir.
Now, can you explain to the jury how you go about doing that? So how do you go about getting a reporter or a newspaper to say positive things about you or the Trump Organization?
So I know many of the journalists, reporters in the various different newspapers and have a long-standing relationship with, again, many of them. What I would do, depending on what the issue is, whether it's a construction, an acquisition, whether it's something to do with one of the various businesses that fell within the umbrella of the Trump Organization, I would reach out to them And I would ask them if they would be interested in doing an article about this specific topic, that I would give them the exclusive on it.
That was one example. If you learned, oh, now let's take the opposite. If you learned that a reporter or a newspaper or magazine was going to write something negative about the Trump organization or the Apprentice or President Trump himself, what kind of steps would you take, if any, to either get rid of that story or to minimize the negative press?
So that's a little bit different. One of the things is instead of me calling the journalist was calling me to send an email to somebody at the Trump organization saying, we're writing a story about whatever the topic may be. We have a deadline of, say, 5 p.m., so we would like for you to comment on the topic. What I would do then is I would immediately go to Mr. Trump's office and I would discuss that specific topic with him, and we would come up with a response, a way to craft a response that I would then take back to the journalist.
You did that a lot. Is that fair?
That's fair.
You had a Rolodex full of reporters' contact information. Is that right?
That's correct.
So you wouldn't always have to go into President Trump's office to ask him how to handle the story. You often just handled it on your own, depending on the story, correct?
No, sir.
You never reached back out to a reporter ever without first checking with President Trump?
It was my routine to always advise Mr. Trump, because if the story that I was going to put out is not the way he would want it, one, it would cause him to blow up at me, and two, it would probably mean the end of my job.
Over the course of 9.5 years, every time that you worked to change the narrative of a story, you did that never on your own, only in consultation with President Trump.
For the story, yes, always in consultation. But remember, one magazine, one newspaper would pick up the same story. So I would use the same statement over and over and over again. So with those, I would not go to Mr. Trump and tell him. I would just send it out of my list of reporters. Or if they contacted me, hey, we're looking for a comment on so-and-so. Generally, what would happen after one newspaper put out a story, somebody else tends to follow. And so we just mimic the same response to the next magazine or the next newspaper and so on.
There were plenty of times, Mr. Cohen, in 2015 and 2016, for example, that you would comment about stories without speaking to President Trump at all. Isn't that true?
No, sir. I would always get a comment or something in line with the conversation that we had on that specific topic. Again, if I did that and he didn't like the response, it would probably cost me my job.
But you knew when President Trump was running in 2015 and 2016. You knew the campaign at times was very frustrated with you because you were going off message from what President Trump and the campaign wanted, correct?
I knew they were upset about it. However, Mr. Trump had turned around and advised me I don't answer to them. And so he's free to speak on his own, and I was not part of the campaign. I was a surrogate.
So your testimony is that the frustration towards you didn't come from President Trump, but it came from the campaign staffers.
Correct.
Going back to 2011, eventually President Trump says, I'm not going to run.
That's correct.
Several months later, you work with Mr. Davidson to cause the Dirty to remove the article about Ms. Daniels, correct?
Correct.
That was in May or so. President Trump said he wasn't going to run, correct?
And it was around the sweeps at the time.
Much later in 2011 is when the Dirty article came down and you talked to Mr. Davidson, correct?
Yes, sir.
So fair to say that the first time that you heard about the incident and the story by Ms. Daniels is when you talked to President Trump about it. He said that he was worried about what his family would think, correct?
Yes, as well as, of course, for the brand.
Well, do you recall meeting with law enforcement on February 18, 2021, and saying that the first thing that President Trump said to you was that his family won't like that very much? It's true, right?
That's true.
And often, including on that occasion, you handle that type of story by threatening legal action, right?
Yes.
Whether it's a cease and desist by you or by another party, that's a frequently common way that you handled negative stories or stories that you wanted to be taken off of websites and not be published.
Along with, the Dirty was actually effectuated by Keith Davidson, not by myself.
Understood. But my question was, who did it? The question was, the plan was for you and Mr. Davidson to threaten legal action. A letter was written by Mr. Davidson and it worked?
Yes, sir.
The way you handled it, that wasn't unusual. You handled it many times for President Trump that way, threatening legal action, writing a letter, or having somebody else do the working for you with, right?
Not necessarily a letter. Many times it was just via phone.
And that's not unique to you. That happens all the time in litigation when a party's trying to get a story taken down, right? For example,
Objection.
Sustained.
you've used that tool many times over the years, correct?
Yes, sir.
And some of the reporters that you had a very strong relationship with include folks like Chris Cuomo, yes?
Yes.
Katie Tur.
Yes.
And we talked a little bit on Tuesday about a reporter named Maggie Haberman.
Yes, sir.
So talking for a few minutes about Ms. Haberman, who does she work for?
She's with the New York Times.
And over the years, well, let me ask you this. When did you first meet Ms. Haberman?
Over 20 years ago.
So you met before, so early 2000.
Yes.
Over the years, you have a very strong, would you describe your relationship with her as very strong?
I would.
You asked her to write positive stories about you, correct?
Correct.
As a matter of fact, when you started in your official role in 2017 as President Trump's personal attorney, you asked her to write a story and say what a great idea it was?
I asked her if she would write a story.
That was my question. You asked her to write a story saying how good it was that you had that role for President Trump, right?
Yes, sir.
And in exchange for that, you would give tips to Ms. Haberman, correct?
Not in exchange. I would use Ms. Haberman if the story was something that I believe the New York Times would run. And if it wasn't the New York Times style story, I would go to a different newspaper.
But there were a number of times when you gave Ms. Haberman a scoop, as you testified about on Tuesday.
Yes, sir.
Even at times, by the way, you recorded a lot of conversations that you had with reporters, right?
No, sir. I wouldn't characterize it as a lot.
How many would you characterize it as?
40?
So 40 with 40 separate reporters, or just a handful of reporters that you recorded?
Over the 10 years, it was probably a little more than a handful.
Why did you record conversations you were having with reporters?
I used to use the recordings as well, as sort of to memorialize it for note taking, so I could go back and listen to it instead of not paying attention when I was talking to them, especially if it revolved around being a surrogate for the campaign. That way, I could use the conversations to figure out what was the best response when I was on television so that it made sense and that it was what I believed Mr. Trump would want.
Well, have you stopped? Did there come a time when you stopped recording conversations with reporters?
Yes, sir.
When was that?
After the election,
After which election?
2016.
You didn't record conversations with reporters in 2017 and 2018?
I would have to check.
We'll check together in a minute.
Okay.
Did you at one point, do you recall sharing a recording that you had made of another person with Ms. Haberman to help her write a story?
I'm sorry. One more time?
Do you recall in 2018, in February, sharing with Ms. Haberman a recording you had made where you recorded a different person to help her write a story? Do you recall that?
I recall sharing a recording.
Well,
I don't
let's
remember
show
the exact nature of it.
Let's show you. If I may, B174, just for the court, the witness, and the parties. And if we can go to page 295. So you see a back and forth text there between you and Ms. Haberman, and then you see the title of the article. We can go to the next page, and then you can see that you received an article from Ms. Haberman. Then you answer her back at the bottom in green. Can you take a look at that?
Yes, sir.
And you say, you can take that down. To help her write another story, you're going to share with her a recording that you made of another individual, right?
That's correct.
By the way, did you tell people you were recording them?
No, sir. I'm a slime ball. No, sir.
Do you remember on several occasions people asked you if you were recording them and you said no on the recording?
No, sir.
You don't remember that?
I don't remember that specifically. It's not illegal in New York for one party.
Mr. Cohen, I didn't ask you whether you were breaking the law. I just asked you if you told the people you were recording them, and you didn't, right?
That's correct.
Ms. Haberman over the years has written a lot of articles about you.
I don't know how to characterize a lot.
Is 38 a lot?
Sounds like a lot, yes.
Well, let's take a look at B242, just for the witness, the parties, in the court. Take a look at what's just a screenshot of a number of articles that Ms. Haberman has written about you, including as recently as 2 weeks ago, right?
Yes, sir.
Does 38 articles sound about right?
I didn't participate in all 38 of these.
My question is, one of the reasons why you want relationships with reporters is to give you an opportunity to respond before an article is written, right?
Correct.
To give you an opportunity to push information to the reporter if you think an article should be written, correct?
Correct.
Also to shape an article. So maybe that's not the word you would use. You can pick the word. But to make the article come out in ways favorable to you, or at the time, President Trump, as possible, right?
That's correct.
So the example I just went through with Ms. Haberman, you had several reporters where you had the same relationship.
Yes, sir.
Now, with reporters, you communicated over text,
Yes, sir.
Signal,
Yes, sir.
Dust,
Yes, sir.
WhatsApp sometimes,
Sometimes.
obviously on the phone.
Yes, sir.
Did you distinguish among those types of communications depending on the story or the reporter, or it depended on what you were using with the reporter?
Depends on what I was using with the reporter. If it was a private or unusual type of situation, I would go to one of the encrypted apps.
Now, you said that you recorded approximately 40 separate times with reporters, but there were 95 secret recordings on your iPhone.
Correct.
Who were you recording besides reporters?
This gentleman that you showed me,
Which gentleman?
Fromer.
Which gentleman?
Fromer. He's not a reporter.
When you say the person I just showed you, you mean the recordings you were sharing with Ms. Haberman was a recording between you and that individual, right?
Yes, sir.
That's one. I'm not looking for you to name, 55. Oh, I'm
The reason I'm bringing him up, I'm bringing him up,
Be-
because there were multiple recordings of him. That's why I said there were about 40.
So besides him, you recorded, who else did you record surreptitiously? It was reporters, that individual, who else?
I recorded off the top of my head, I can't tell you, Jeff Zucker on one event, Mr. Trump on another event, and there are other reporters.
Let's talk about the recording that you made of your then client, correct? President Trump.
Correct.
You understand that it's not ethical for a lawyer to record the conversation with their client, correct?
That's correct.
And you were a member of the New York Bar at the time.
I was.
You know that there are a lot of New York Bar opinions on this, but unless there's a very specific circumstance, you're not supposed to record your client, correct?
You're not, except, of course, crime fraud exception rule 12.
The crime fraud exception, didn't you testify that you recorded your client because you wanted to convince Mr. Pecker that money was coming?
That's correct.
So are you saying that you did the recording under a client fraud exception?
No, you asked if there are exceptions, and I said yes, the crime fraud exception rule.
So
I was just giving an example.
just so I understand it, you surreptitiously recorded your client so that you could play a privileged recorded communication between you and your client with a third party That's what you did, right?
That's correct.
And again, you certainly didn't tell President Trump that you were recording him, did you?
I did not.
Now, you talked about 2015 when 2015 when President Trump announced he was going to run, and he comes down to Trump Tower, and he comes down the escalator, correct?
Yes, sir.
Prior to that, President Trump had launched an exploratory committee in March of 2015, right?
Yes, sir.
And an exploratory committee is a step in the right direction for someone who may seek to run for the office of the presidency of the United States, correct?
Correct.
And in June of that year is when he announced, correct?
Correct.
And this is a meeting where you all discussed
I think
what
it's good.
National Enquirer,
I think-
Mr.
I think it's
Pecker.
I think it's good. This I jumped on you.
Oh, I'm sorry.
That's all right. Let me just grab a couple chats that came in real quick.
Yeah, let's take a
I
breath.
asked on let me just move you so you're visible. I asked Ron Joe if he had wanted a shaft of his own and what tunnel number to name it, and he said, "I got your shaft right here." Well played, Ron. Give him nice, nicely done. And no, sir, I'm not at all a slim ball. He may be a slime ball, but he's not. He's definitely not a slim ball. Real Patriots Party rating the stream. God bless you, Real Patriot Party, bringing everyone in on Rumble. Good job, my brother. All right, let's get back in here, doing our thing.
Okay.
This feels. I gotta tell you something. This feels like you. Everyone notice how Ron is throwing himself into this role. He's doing it the way like a litigator. He really. It's amazing. What your read of this is just awesome. Like,
Thank you.
wait, much better Blanche than I was. That's for sure. Go for it.
Now, you testify that you have a very specific recollection of a meeting that you had when at Trump Tower, with yourself, President Trump, and David Pecker, correct?
Yes, sir.
And this is a meeting where you all discussed what National Enquirer, Mr. Pecker, would do to help President Trump, correct?
Correct.
You testified earlier this week that the so-called power of the National Enquirer is its placement in supermarkets, right?
Correct.
But you never said that to the grand jury, did you?
Objection.
Sustained.
That's not something. Did you ever discuss the power of the National Enquirer's placement in the supermarket with anybody prior to your testimony on Monday?
Objection.
Overruled.
I'm so sorry. One more time, please.
Prior to your testimony earlier this week, when you testified that the power of the National Enquirer is its placement in the supermarket, my question is, had you ever told anybody that before your testimony this week?
Not that I recall.
Now, and when we talked about this Tuesday afternoon, but you learned about what Pecker testified about in this trial, didn't you?
No, sir.
You didn't say on TikTok, from everything I heard from people today, David Pecker is basically corroborating what I've been saying for years.
Yes, that's a general statement.
Because people told you about Mr. Pecker's statements. You testified about that on Tuesday, correct?
What David Pecker was testifying to, people just corroborated that it corroborates my story that I have been talking about for the last 6 years, not the specifics.
So, and you testified thereafter about a story that the National Enquirer folks alerted to you involving Dino Sajudin, right? Correct?
Correct.
Now, you testified a lot about that on Monday, but that story, by the way, is completely false, correct?
Yes, sir.
And by completely false, I mean money was paid to keep the story from getting out, but the story was false, correct?
I believe so, yes.
Well, do you have any doubt in your mind that it was false?
No, sir.
And isn't it true that at the time when you talked to President Trump about this false story, he was worried about the story getting out because of his employees, right?
He mentioned that I should speak to them as well. Yes.
Well, he told you, did he? You previously told law enforcement that he told you that he was concerned about the story because it involved people that still worked with him and worked for him, correct?
Yes, sir.
And so it was important to him to keep it from getting out, correct?
Objection.
Yes, sir.
Now, You testified on Monday. You testified on Monday when you were talking about this story that you kept President Trump updated all along the way, right?
That's correct.
And there was a liquidation clause in that contract, correct?
That's correct.
You never told President Trump details like that, did you?
No, sir.
So things like that within the contract, you were the lawyer, you were his lawyer, you handled it, right?
Yes, sir.
Now, as it relates to the Ms. McDougal story, which you testified about earlier this week, you testified that you were worried at the time that this story would have a significant impact on the campaign. That's what you testified to, right?
Correct.
But President Trump didn't share your view, did he?
I'm not sure I would agree with that.
Didn't you previously tell the government that President Trump said he didn't think this story would hurt him?
I would need to see that document, please.
Sure. If we can show the witness what's been marked for identification as B127, just for the witness, the court, and the parties. Take a look at that. Notes from a March 7, 2023 interview.
Which bullet point, please?
If you get to the third bullet point, Mr. Cohen, you can stop there.
Yes, sir.
You can take that down. Thank you. So let me just re-ask my question. When you testified that you believed that the story would have a significant impact on the campaign, my simple question to you is, at least initially, my question to you is that President Trump, at least initially, didn't think it would hurt him, correct?
Initially, yes.
Now, you've also told the government that one of the things that President Trump was worried about as it relates to this story was his family, right?
Yes, sir.
And his family meaning his wife, but also his children, correct?
Correct.
Now, you testified that you testified on Monday. Do you have a recollection of a telephone call with President Trump on June 16, 2016? Do you remember testifying about that?
Yes, sir.
Now, they showed you some text messages with Mr. Schiller. And that was another time that you testified that you called Mr. Schiller and he gave the phone to President Trump. And that you have a specific recollection you testified and you recall providing him with updates. Do you remember that testimony?
I do.
You don't have a specific recollection to a telephone call that you had in June of 2016, do you?
No, sir.
And just to put some context around that, I'm not quibbling with your answer. It was a long time ago, correct?
Yeah, that's correct.
At that time, how many phone calls do you think you were getting in a day?
Many.
Many, like 20
Hundreds.
a day?
Sure.
Well, let's just say 50 a day.
Okay.
So that means you're getting about 350 a week. Is that right? I know you're estimating.
Yes, sir.
It's around 1,400 a month, right?
Yes, sir.
So we're talking about conservatively 14,000 calls a year in 2016 to 2017.
Yes, sir.
And the same would be true basically 2018. And then until you went to prison for 13 months, that number's about right.
Yes, sir.
So, and I know we're just estimating, we're talking about more than 50,000 phone calls between 2016 and today. Would you agree with that?
Yes, sir.
And so when you testified on Monday and Tuesday about specific conversations that you had with different folks, Mr. Pecker, Mr. Howard, President Trump, you were not testifying from a specific recollection of that phone call, were you?
I was.
You were.
I was.
So 50, 60,000 telephone calls later, you have still specific recollections about phone calls.
Because these phone calls are things that I've been talking about for the last 6 years. They were extremely important, and they were all consuming. So while I did not know that it took place at 8:02 p.m., what I did recall is the conversation that I had, not the specific time in the conversation, but rather the specific sum and substance, because it was such a significant event, and because I've been telling the same story about it for 6 years.
So your testimony is that you've been talking about these phone calls for 6 years?
That I mentioned of these phone calls, or the specific phone call where I had advised Mr. Trump that I was going across the street to First Republic Bank, where I had just done the transaction. Everything is done because it was that significant.
I'm talking right now about this June 16, 2016 phone call that you testified about on Monday and Tuesday, okay? You testified that the prosecutor asked you whether you had a specific recollection. You said that yes, that you had a specific recollection.
Objection, Your Honor.
Overruled.
And so what I'm trying to do is reconcile what you said a few minutes ago, that you don't have a specific recollection, with what you just said, which is that you do. For this phone call, do you have a specific recollection of this phone call in June of 2016?
Can you show me which phone call we're referring to?
Sure. If we can put it up, it's already in evidence, People's Exhibit 349. And if we can go to June 16, 2016, that phone call at 6:51 p.m. and just blow that up, please.
I'm sorry. Which date are we looking at?
And we should be able to blow it up for you, Mr. Cohen. We're looking at a June 16, 2016 phone call at 6:51 p.m. Do you see that?
I do.
And how long was this phone call?
2 minutes and 31 seconds.
So just so I understand your testimony, as you sit here today, you have a specific recollection of that phone call on June 16th, 2016.
Based upon the other documents that I was able to look at, what it did was jogged into my memory, again, the story that I've been telling in regard to this conversation.
I'm still looking for an answer. Do you have a specific recollection or do you not have a specific recollection?
Objection.
I recalled, as I
Actually,
had
can I
stated.
interject something real quick?
Yeah.
I have a question. Why am I not getting an answer to this objection?
Probably he starts talking before the judge weighs in.
Okay, I was just curious because that was like the second time that it was happened. And how does that affect the record, though?
Well, it's sometimes if the witness answers too fast, that just happens. Normally, it would be a short answer, like last time it was a 2-word answer. This long answer, usually a judge would interject on the witness. It's a little weird that Cohen's getting such a long objection, a response out with the objection still pending.
It could
It's not-
be
Okay,
that-
sorry, that was just confusing to me because
No, you're asking a very good question. It's also possible that the judge is kind of just gesturing,
Yeah, he's gesturing like overruled with his hand.
not happening.
Okay.
Oh, like a sit down motion kind of thing. Could be any of those.
Okay.
Which is not great form, but this is not a great judge.
Well, I
I was-
am surprised about the times when the objection is made and it doesn't get overruled or they let him answer or whatever. So
Yep.
I
Yeah.
mean, I don't know. I expected that he would get a lot more.
In all
I
the
don't know.
testimony we've gone through, this is the first time that we've seen it, and
Okay.
this is 100% spec. What I'm about to say is 100% speculation. It could be that at this juncture, Judge Merchan has
He's
given
really
up
not
on Michael
liking-
Cohen.
Really
He's
not liking Michael.
He's
Cohen.
not liking Michael Cohen. He's not liking the prosecution for putting him up here, and he might be
Yeah.
reassessing everything he thinks about this case at this point.
Yeah,
because
I'm
That
having the
makes
same
sense.
thought.
because it's like, just shut up and
Okay.
sit down. Like, this is you know what crap you threw up here in front of in my court. Some judges take it very personally that you're throwing up evidence here and testimony, which, like I said, the testimony was completely blown out on cross-examination right before lunch. This is right after lunch, and it's very possible that he's feeling a certain way about Mike Cohen and the prosecution at this juncture.
Mhm.
Also, this guy,
Makes sense.
I can't get across to people enough just how offensive it is. The idea of a lawyer recording conversations with his clients.
Yeah, that's gross.
Yeah.
There is nothing. This is like such a third rail. It's not just it's unethical, it's some kind of technical thing.
What
You're
if I recall a conversation that I have with my lawyer?
so
That's
if you
very different.
that's
very
right.
different.
That's your
He's working
prerogative.
for you. He's working for you.
We
Okay.
we really urge clients not to do that
Okay.
for the same reason that we don't. You're going to tell me stuff that I'm going to tell you I don't want to hear again, or that you need to couch
okay.
that differently in the future, or that that's a fact that we really don't like. You're by recording it, I'm making a record of things that, well, that's the whole purpose of confidentiality. Anything that's recorded, as we have learned here, has a very, very high potential
Yeah.
of becoming public. All right,
And
let's go
attorney-
back to the record.
And attorney-client privilege goes in favor of the client. So for me to be
Mhm.
recording you as
Yeah.
my client, it's almost implying I'm planning on breaching this confidentiality. When you are recording it, you could be taking notes to remember or stuff like that, or different things. And it's that firing me is at your pure discretion also. And you can waive the attorney-client privilege anytime you want. So you recording it is not nearly as gross in this atmosphere, because I'm supposed to be sitting here as a servant of you, and here I am. I'm undermining that service by basically preparing to stab you in the back. And it's everything
Yeah.
negative that people think about attorneys.
That makes sense.
And by the way, the only other thing that's as big a third rail as this is basically stealing money or commingling funds. And that's the same thing. You're stabbing the guy in the back and basically doing things that you're not supposed to do. Let me hit a couple super chats and we'll get right back into this. So, Melanie Haydick. Oh no, I'm not making enough money complaining about Trump. Apparently he wasn't. Kat, member for 2 months. Ron, whatever state you work in, I'll behave because I don't want you questioning me. If I need a lawyer, I want you on my side. Thank you for tonight. He's doing a great read here. All right, so getting back to it, I recalled, as I stated before, I recalled the conversation based upon the other documents.
Well, I understand that, but my question isn't whether you recall a conversation. I'm asking whether you recall that conversation on that phone call at that time on that day in June of 2016.
Again, based off of the documents that I had looked at and reviewed, I did.
Well, do you remember, for example, speaking for a very long time with Chris Cuomo just mere seconds before this call?
Yes, sir.
And what were you talking to Mr. Cuomo about?
We were talking about my appearance and we were talking about different topics.
Were you talking about your feelings? I didn't hear.
Sorry. Gotta mute myself.
I was talking about my appearance.
Your appearance. Got it. Your appearance to be on his show?
My appearance, my feelings. Yes, sir.
So you now also have a specific recollection of a conversation you had with Chris Cuomo 8 years ago.
It was over an hour. It was a very long conversation. And again, I recorded it as contemporaneous note-taking so that I could pay attention to the conversation. I can ensure that the things that I brought up in his show were the things that I wanted to say. So I crafted my responses.
And you remember that conversation today?
I remember having the conversation, yes.
I want to talk a minute about the recording that you did surreptitiously with President Trump. Now, that recording was about 2 minutes, 51 seconds, right?
Correct.
And you didn't actually start talking until about a minute into the recording. Is that correct?
That's correct.
And you were talking to President Trump at the time about transferring information regarding our friend David, which was Mr. Pecker, right?
Correct.
And the information you were talking about transferring was supposedly all kinds of a secret box about bad information on President Trump, right?
That's correct.
And at that time, there was a concern because AMI was looking to potentially acquire Time magazine, or the other way around, right?
No, sir.
Or what was happening?
David Pecker was being considered to be the CEO of Time Incorporated, Time magazine. And the concern was being that these documents were the property of AMI, that he would not be able to, of course, take them. That whoever the new CEO might be may end up not being as supportive of Mr. Trump as David was. And so we were concerned that potentially one of those stories could be leaked.
And President Trump said he could get hit by a bus, meaning something could happen to Mr. Pecker, and the rest would be the same, correct?
Correct.
Now, the concern here was even beyond the election, right? Meaning this conversation wasn't tied to the election. It was a real concern that Mr. Pecker could get hit by a bus at any time or something could happen to him, and you guys wouldn't have those files, right?
Yes, sir.
Now, and you said, I'm all over it. You said, I'm all over it, right?
Yes, sir.
So eventually you learned that there was nothing in those files, correct?
I was told by Mr. Pecker that not to worry. There's nothing in the files.
That was later, though, right?
After he was not accepted as the CEO of Time.
And then you testified about a comment that was made in response to a question about financing. And President Trump says, what financing? And then there's a comment made about cash, right?
Yes, sir. Mr. Trump turned around and used the word cash.
And when he says cash, he's not talking about Benjamins and green dollar bills, right? He's talking about paying for something with cash, not financing, right?
No, sir.
Well, isn't it true that over the time you worked for President Trump, he would often purchase things with cash, correct?
Correct.
As a matter of fact, you talked to the prosecutors on multiple occasions about the fact that President Trump would purchase buildings with cash, right? At times?
I don't know what you're referring to, sir.
Well, were there times when President Trump acquired property, whether it's a golf course, whether it's a building, and paid cash, meaning no financing, right?
Yes, sir.
That happened, right?
I may have said that using that term. Yes.
No. Put aside the term. I'm just asking you, separate from that. There were times when President Trump bought property as part of his business and didn't finance it, right?
I'm not aware of that.
Well, you're aware that you said that there were certain properties that President Trump paid for, just paid cash, right?
Yes, that was the message that I was to use, that there's no financing. He's very rich and that he paid all cash.
Yes, but my point is, Mr. Cohen, when you say he's very rich and he pays all cash, you're not saying that you or Mr. Trump or his sons go to the bank with a bunch of bags full of cash and buy something. You're saying that it's not financed. We're just going to pay with cash. We're not going to finance, right?
That's correct.
When you testified on Tuesday that President Trump, when he said cash, was talking about green, that's not what he's talking about, is it?
It was, which is why, sir, I used the word no check. We need to do it by check.
Hang on for a second. When you say we need to do it by check, that's when this audio gets cut off, right?
It was not exactly after that. It was after I received a phone call.
Right. As you say, check, or the word check is said, it cuts off right then, correct?
No, I believe there's a few seconds more where I say hello to somebody on the phone.
Now, which phone did you make that recording on?
On one of the two phones.
When you say one of the two phones, you mean one of the two phones that the FBI took from you in April 2018?
Yes, sir.
And that's one of the two phones that they eventually returned to you, right?
Yes, sir.
And that's one of the phones that you eventually gave to, with consent, to the people, right?
Correct.
Good. If we can put up what's already admitted into evidence, it's 248. If we can, this is a transcript that we talked about on Tuesday, Mr. Cohen, right?
Yes, sir.
Or Monday. If we can go to the second page, you'll see that the last thing that's said is Donald J. Trump, check, right?
Correct.
Now we can take that down. The conversation continued, correct?
The conversation continued. Yes.
And you received a phone call from a bank, right?
Capital One Bank.
And your testimony is that you answered that call.
I did.
So just so I understand, you're in a meeting with President Trump, talking to him about the finance or cash for the McDougal story, and you're recording him, but the phone rings and you just answered that call.
I did.
And what was the bank calling you about?
I don't specifically remember. I just remember it was a big issue.
If you don't have a recollection.
If my recollection is correct, I was the subject of identity theft the second time. People were going into the account and taking money out.
Wait, you remember or you don't remember?
I believe that's what it was. I'm not 100% certain.
Hold on a second. Well, you started out saying you don't remember. Then you gave a long explanation, and then you said you do remember, but you're not 100% certain.
Objection, Your Honor.
Sustained.
Now, when you hung up with that phone call that you had with the bank, were you still talking to President Trump?
For a few minutes more, yeah.
You didn't restart the recording.
No, sir.
And the transcript of the recording, you could hear what you say is you are answering the phone, right?
That's correct.
So did you have two phones at the time?
I had two phones at the time, yes.
Did the call come in on the phone that you were recording President Trump on?
Yes.
You sure about that?
Positive.
You testify. I just want to talk for a few minutes about your testimony about the use of encrypted apps as it relates to communications you were having with Mr. Pecker, Mr. Howard, and others associated with the non-disclosure agreement, correct?
Correct.
You testified that you would use those apps at times because you wanted to keep conversations confidential, right?
Correct.
But you'll agree with me that a lot of the most key communications regarding that deal, the deal with Ms. McDougal and also the NDA with Ms. Daniels, were just on texts, right?
Yes, sir.
And the documents, the NDA, it was just email back and forth, right?
Between myself and Mr. Davidson, yes.
Right, but you weren't using Signal to send the NDA, were you?
No, sir.
You just emailed it.
Correct.
Mr. Blanche, can we take our break now?
Sure.
All right. Jurors, let's take our afternoon recess. We'll see you in about 15 minutes.
Whereupon jurors exit courtroom, witness excused.
You may be seated. Can I have one attorney from each side and the court reporter join me in the robing room?
And they had proceedings in there. All right. So we only got we're moving along well here. This is really good. Okay. By the way, people yell at me that I don't promote my Ungag Trump application. If you want to support me, it's a GiveSend where I'm trying to do whatever the hell I damn well can to get Trump ungagged. I'm probably going to end up going to Supreme Court, and likely it's looking like trying to fight in perhaps even over the Washington case. Go to givesendgo.com/ungag Trump. That's givesendgo.com/ungag Trump. It's pinned in the comments section. If you're on YouTube, can't really pin it on Rumble. And also, if you can also check out my work on Locals. And while you're here, like and subscribe, do all that good stuff. Good stuff. Anyway, phenomenal reading so far. Let's move forward. Lieutenant says, please be seated. Come to order. Part 59 is back in session. Part 59 is a reference to Judge Merchan's part. In New York, different parts are assigned, different courtrooms. The courtroom where things are conducted are each assigned a part number. So his part is part 59.
All right. So we had a conference in the robing room with one of the alternatives who has indicated a conflict.
Alternates,
who has indicated a conflict. Counsel was there. Have you had a chance to fill in your colleagues on what was discussed?
You can go with that, Chugi. It's prosecutor. You can go with that if you want.
Me, you said?
Yeah, do it.
Okay. Yes, I think our suggestion is let's just not promise the jury that they are going to be able to go home at 1 o'clock Thursday. Let's wait and see where we are in terms of what part of the case we are up to, and then decide if it's feasible. It's an alternate juror. We can decide whether to keep the alternate juror or release them, depending on where we are at.
Yeah,
Just to let you all clear, by the way, that an alternate juror is not someone who they're anticipating is likely going to play a role in the outcome here. So that's why they're going to be less accommodating. They'll likely be far less accommodating. If the rest of the jury is okay and it's just an alternate, they're much less likely to be accommodating to that alternate. Probably, I would think.
more likely to be accommodating.
To an alternate than a regular juror?
Oh, in other words, I guess we're meaning accommodating in a different sense.
I'm saying is that they're more likely to just say, all right, goodbye, alternate, than they are.
Right, exactly, right.
Right. That's
So, yes, and Mr. Blanche says that makes sense. I think our view would be if it comes to it, we need the afternoon, which we probably will. We can address it then.
Okay, I agree. Let's get the witness, please.
witness entering courtroom was properly seated.
Let's get the jury, please.
Yes, Judge. All rise. Jury entering the courtroom.
You may be seated.
Case on trial continue. All jurors are present and properly seated.
Mr. Blanche.
I want to talk for a few minutes about the $130,000 payment you made to Mr. Davidson, okay?
Yes, sir.
So, by the way, you learned from Mr. Davidson along the way that another news organization was interested in buying Ms. Daniels' story, correct?
Correct.
And at that time during the process, did you hear that from Mr. Davidson?
After we had failed to transfer $130,000 as per Mr. Davidson's cutoff date.
The news organization or the organization that was interested in Mr. Davidson told you was ABC, correct?
ABC, and I believe it was also Daily Beast.
Well, that was later.
Yes, it was ABC.
So, and in particular, you were told that ABC had offered, in essence, the same amount of money Mr. Davidson was trying to get from you, correct?
Correct.
$130,000?
Yes, sir.
Who is the reporter that you put aside whether it's true that Mr. Davidson told you about that was trying to negotiate with Ms. Daniels?
I'm actually blanking on his name.
Was it an individual named John Santucci?
John Santucci, yes, sir. ABC News.
And you never confirmed one way or the other whether that was true.
I spoke to Mr. Santucci about it.
When did you speak to him?
He contacted me and asked me whether or not I was responsible or I knew that we were responsible for them not getting the story. John Santucci used to come to my office quite a bit.
So, and you talked about that interaction you just talked about in a recording that you made with Mr. Davidson, March 27, 2018, correct?
Correct.
So do you remember when that phone call, that meeting with Mr. Santucci was in relation to 2016, October, and when you told Mr. Davidson about it in March of 2018?
I said October.
So what did you say to Mr. Santucci, and what did he say to you?
First, I was a little shocked that John Santucci actually did it, meaning he had to spend quite a bit of time following the Trump campaign. And then, of course, he denied that they were involved.
Now, do you recall Mr. Santucci asking you whether you, meaning Mr. Cohen, were able to kill that story because he said that Ms. Daniels had gone dark?
Yes, sir. That's what I was saying before.
Okay, understood. Now, when you met with the district attorney, with Mr. Pomerantz, so a while ago, do you remember saying that you believe that Mr. Davidson, on behalf of Ms. Daniels, was engaging in extortion?
Objection.
Overruled. You can answer.
Yes, I recall making a statement like that,
What statement did you make?
that they were extorting Mr. Trump.
And the reason you said that is because of all the factors you talked about on Monday or Tuesday, right? You said that there was urgency because of the Access Hollywood tape, correct?
Correct.
And there was an election, and in your mind, there was either two choices: pay it or don't pay it, and the story comes out, correct?
Yes, sir.
But you went a long time without paying, correct?
Yes, we went several weeks without paying.
And ultimately, though, you did.
Yes, sir.
We'll talk about that in a little bit. But you referred in direct to this payment as a hush money payment. Do you recall that?
Yeah, it's been called the hush money payment.
I'm not asking whether it's been called that. I'm asking whether on direct you referred to it as a hush money payment.
Yes, sir.
And do you recall the prosecutor saying it was a payoff? And you said yes? Do you remember that?
Yes.
Make no mistake, this was a completely legal binding contract.
Yes, sir.
Let's pull up Exhibit 276. It's in evidence. You testified about this on Tuesday. This is a very long contract, correct?
Correct.
And it's signed by you, right?
It is.
And Mr. Davidson?
Yes, sir.
And Ms. Daniels?
Yes, sir.
But Donald J. Trump never signed anything associated with this agreement. He didn't sign this agreement. He didn't sign the side letter either, correct?
That's correct.
But in your mind then and now, this is a perfectly legal contract, correct?
Yes, sir.
What I mean by that is a non-disclosure agreement, an NDA, a settlement agreement between two parties, happens all the time, right?
Yes, they do.
Now, you testified that there were two names used, Peggy Peterson and David Dennison, right? Pseudonyms? They're not real names, pseudonyms.
Yes, sir.
Who came up with those names?
Keith Davidson did.
Do you know why?
I believe he knew a David Dennison and Peggy Peterson. I don't know the answer.
Now, you testified that you have, again, still focused on the legality of this contract. You testified that you lied on the account opening documents with your bank and said that it was going to be for consulting because you were worried that if you told the truth, they would have further questions, correct?
Or they wouldn't open up the account.
Or they would say, no way, we're not doing it, right?
Correct.
But you agree with me that there's nothing illegal about a settlement contract between two parties, both of whom had lawyers, right?
Correct.
And you weren't interacting directly with Ms. Daniels. You were going through Mr. Davidson, correct?
Yes,
And you testified you never met Ms. Daniels until the podcast, right?
that's correct.
And similarly, you were a lawyer at that time working on behalf of the Trump organization, right?
Yes, sir.
Working on behalf of
Judge, may we approach?
Yes.
Oh, I'm sorry. Is it my turn now?
Yeah.
I think there have been more than a few questions now about the lawyers involved in this contract. When we were at a similar place with Keith Davidson, Your Honor sustained an objection. Defense counsel has persisted with the presence of counsel issue, and so I just want to alert the court. I think at this point 2 or 3 questions have been asked about a lawyer. I didn't object. Now I'm going to start objecting.
What's wrong with asking what the lawyers?
Well, what's wrong with it? It is a very slippery slope. As you know, we dealt with the whole presence of counsel, appearance of counsel, advice of counsel, and we don't want to go there. In fact, on this, unless I'm mistaken in reviewing the proposed jury charge, there was an instruction there regarding the presence of counsel. So I would stay away from that. I think you asked enough questions on that.
Thank you.
What? What?
Hmm.
What do you
Now-
what do you make of that, Ron? Before we get to what do you make of that?
Well, I don't know. I don't know what the earlier.
Right.
I don't
That's
know what the
true. I
motive
didn't see
is.
that either. I didn't see that either when they were talking about it. All right. Obviously, yeah. Obviously, this relates to conversations probably from the Davidson. I assume it's from the Davidson thing. But
Now, you
All right.
testified about your work for the Trump Organization. You reported directly to President Trump, right?
correct?
And over the 9.5 years you worked for the Trump Organization, you did work for the organization, legal work, right? Correct?
No, not much legal work.
Well, were you assigned, for example, to help with new projects, potential new projects?
Yes, sir.
That's for the Trump Organization, correct?
That's correct.
And you worked on The Apprentice, right?
I assisted in The Apprentice. Yes,
That was for the Trump Organization, right?
that was certainly for Mr. Trump.
No. You're telling me that you worked with The Apprentice and it wasn't for the Trump Organization, it was for Mr. Trump?
I'm not sure if The Apprentice was for the Trump organization as opposed to Mr. Trump personally.
Well, was the money made from The Apprentice part of the Trump Organization revenues?
That I wouldn't know.
And then you did personal work for President Trump, right? Correct?
Correct.
And you did personal legal work for some of the kids, right?
Yes, sir.
You said you didn't recall doing any work for Eric Trump, but for Donald Trump Jr.
Yes, sir.
and for Ivanka Trump, yes?
Ivanka, I said I couldn't recall, but it seems possible.
And for Melania, President Trump's wife as well, right?
Yes, sir.
You never had a retainer agreement with any of those individuals, did you?
No, sir.
And the reason why you didn't have a retainer agreement is because you didn't need one, right?
Correct.
And you didn't need one because you were employed by the Trump Organization, correct?
That's correct.
And so you knew you were going to get paid, right?
Yes.
And there were some parts of your salary you didn't know. That would be your bonus. You knew your salary.
Yes, sir.
So you didn't have to worry when you did personal work for Donald Trump Jr. about a retainer agreement because you were getting paid by the Trump Organization, correct?
Correct.
Now, you testified multiple times on Tuesday that when you were President Trump's personal attorney in 2017, you had no retainer agreement, right?
I never had a retainer agreement.
Let's try that again, Joe.
Did I miss it?
Yeah.
I'm sorry. I missed that.
I mean, who cares?
I didn't. Correct.
But the truthful testimony is that in the whole time you worked for the Trump Organization, you never had a retainer agreement, correct?
I never had a retainer agreement.
So it's not just January 2017 that you did not have a retainer agreement. It's from the day you never went back to your law firm and the Trump Organization sent some guys over and packed your bags and you started working for Donald J. Trump and you never had a retainer agreement, right?
No, sir.
And by the way, nothing wrong with that, correct?
Objection.
I am sorry. Can you repeat that, please?
Is there anything wrong in your view? You were a lawyer, right?
Yes, sir.
And you were acting as a lawyer for
Overruled. I'm sorry. The objection is overruled.
you were acting as a lawyer the whole time you worked for the Trump Organization.
Well, I did legal matters and non-legal matters.
Understood. But you did legal matters.
Yes.
And ethically, there was nothing wrong, correct?
I was an employee of the Trump organization. Nothing unethical.
Right. So when you were an employee, you had a job with the Trump Organization, right?
Yes, sir.
And your job was to report directly to President Trump, right?
To whatever Mr. Trump wanted me to do.
You were an executive vice president, right?
Right. Yes, sir.
And if that direction included doing legal work for Melania Trump, for example, you did it, right?
Yes, sir.
And ethically, nothing wrong with that, correct?
Correct.
Because under New York ethics rules, you don't need a retainer agreement to do work for a client, do you?
No, sir.
Now, I want to talk for a minute about, if we can put up what's already admitted in evidence as 201, please. Yes. We went through this letter on direct. Do you recognize this letter?
I do.
This is February 8th, 2018. It's a letter to the Federal Election Commission, correct?
That's correct.
Now, this letter was put in response to a complaint that was filed earlier by Common Cause, right?
That's correct.
Now, I want to first highlight the first paragraph. And your lawyers, by the way, you read this letter before it went out, right? Correct?
Yes, sir.
Your lawyers write that they're writing on behalf of you in response to the Common Cause complaint and that they are responding to it, right?
Yes, sir.
If we can go to the second paragraph. So this second paragraph says, in a private transaction in 2016 before the U.S. presidential election, Mr. Cohen used his own personal funds to facilitate a payment of $130,000 to Ms. Stephanie Clifford. Neither the Trump Organization nor the Trump campaign was a party to the transaction with Ms. Clifford, and neither reimbursed Mr. Cohen for the payment directly or indirectly, right?
Correct.
So, by the way, I believe you testified to this. That's true, right? I know you said that it's
an omission.
But that it is a true statement, right?
That is a true statement.
Meaning you used your own funds to make the payments to Ms. Daniels.
Correct.
And neither the Trump Organization nor the campaign paid you back, right?
Was a party to the transaction. They were not.
Well, they weren't a party to the transaction. That was because they didn't give you any money, right?
No reimbursement. Correct.
Because President Trump reimbursed you from his own personal funds?
Either from President Trump's or from his own funds or from the trust.
So if we can please bring the third paragraph down now, please. This is responding directly to the allegations that were in the Common Cause complaint, right? It says that they're speculative and neither your LLC made any in-kind contributions to Donald J. Trump for president or any other presidential campaign committee. It also said, I think accurately, that you are not a government employee, right? And that's right? That's correct?
That's correct.
And that it doesn't constitute a campaign contribution or expenditure, and therefore the FEC lacks jurisdiction over this matter, right?
Correct.
Now, we can take that down.
This is so pivotal. This is basically saying that he said there's no crime here. He wrote and he reviewed this letter and he said that the predicate crime that New York is now trying to charge him with covering up, that there was no crime. In fact, arguably, one could argue that if he made a donation of that size to the Trump campaign, that there might be reporting duties that he had.
Oh, goodness.
That if he made that donation of $130,000 to them, so it could be that he himself would have all sorts of issues if, in fact, there was a predicate crime here. So it's pretty funny that he's the star witness here, and he wrote a letter saying there was no predicate crime. That's amazing. Amazing how the balls on Alvin Bragg for bringing this case. It's just
Can
amazing.
I ask a question real quick? Would there be any record in Cohen's personal finances to corroborate this $130,000 payment? Is there any?
I think
I don't know.
I think they provided corroboration that there was a payment from his HELOC
Got
to
it.
Keith Davidson that was pursuant to this thing. So that I think they established that the money went, that she got paid, and that she claimed she got 96,000 out of the 130, and that 24,000 went to an attorney and someone who introduced her to the attorney. But that she got paid. That's for sure. She got
Got
paid.
it. Got it.
But before you just jump further, let me just get this. Live reading reenactments are great. Hashtag Ungag Trump. Thank you so much. Master Phillips hitting with the 20. Count them. 20 Good Logic memberships. God bless you, Master Phillips. I would not have thrown that out there. I feel that is awesome. Let me just tell you. JC, the guy who just sent super chat a second ago. Gifted a membership. Mama, Tuxie, Digital Soldier, Cataway, Old of Age Homegirl Basic Female, MJ, Naomi Boyd, Stumpy Stu, Christine McCoy, Brittany Going Insane, Judge Maddie, old school Judge Maddie, Delon Thompson, Jace Clark, Mo Sam, Robert Hunt, Zelda Glitz, Charlotte 0156, Eric Weborg, all of you gifted memberships to the following. The following is not at all a cult type of cult. Please, all of you, give a round of applause to the king of recruitment there, Master Phillips, bringing people into the following. You might think to yourself the following is some type of cult. It's not at all a cult type of cult. I am not the leader of the following. I am not the leader of the following. I'm just a host. The following is not at all a cult type of cult. There's no Kool-Aid, no spaceships, no tracksuits that are mandatory, mild farm work, no goat sacrifices, no squirrel mutilations, no dancing around bonfires while shucking off clothing to the beat of a tom-tom. No sticking your head through doors and screaming, "Here's Johnny." There's really nothing remotely cult-like because it's not at all a cult type of cult. So thank you for bringing them into the fold here. You are the boss man, the king and queen. You and Bella Stella bringing folks on into the following because the following is about personal growth. It's about community,
Joe, the rap that you have
leadership and leadership training. That's what it's about. We're going to proceed now, but thank you so much. It's this
mind-boggling.
Look. Let me tell you something. People get confused about the following. I don't want people being confused. So, and the worst is everyone saying I'm the leader because I'm definitely not the leader of the following. That's
just one of us. One of us. Yes, exactly.
I'm the breaking news person, and nobody ever reads my breaking news alerts, and that's why nobody's clicking on the damn link and donating to you could give us and go. Come on, people. Let's get with it. Let's go. Let's do this.
Yeah, let's get with it. All right. We're going to get back in here because I know Ron, it's like almost sleepy time for Ron.
It's way past sleepy time for Ron. I already missed. No one here is even old enough to get the joke, so forget it.
All right. Okay.
And it doesn't constitute okay. So we can take the. So the complaint was filed before that, right? The common cause complaint.
Yes.
And the complaint is that a public or a sealed document?
Sealed document, I believe.
So, but I'm right that you actually shared a show the complaint to a bunch of reporters before it was public, right?
I believe so.
And that's a sealed document, right? And you're not necessarily giving it to the reporters, but you're showing it to them, correct?
Yeah, I may have showed it.
Well, do you have any doubt that you showed it?
No, sir.
And you were very angry that the complaint had been filed, right?
I was.
And you told some reporters that you were going to seek sanctions, potentially Rule 11 sanctions, right?
Correct.
And at that point, you were sick of having to defend yourself from these frivolous allegations, right?
Yes.
Now, if we can put up 202, which is already in evidence, this is the statement you issued the same day, right?
Correct.
And you wrote that.
Yes, sir.
We won't read the whole thing, but you said on Tuesday that you didn't plan to provide any further comment because you were worried that by issuing this statement, you would start getting a lot of calls, right?
I wrote that, yeah.
And that's why you wrote that on the second to last paragraph, right?
No, sir.
No, that's not why?
That's not why.
I must have understood your testimony from Tuesday. You didn't want to provide any further comment, right?
That's correct.
And the reason why you put that in the statement is because you were worried that if you just sent out a statement without that, reporters would want you to comment, right?
They would be asking me the question in the paragraph above it, quote, neither the Trump organization nor the Trump campaign was a party to the transaction. My concern was that they would expand upon it and they would ask me about Mr. Trump personally or some other account.
Now, if we can highlight the very last paragraph, it says, just because something isn't true doesn't mean that it can't cause you harm or damage. I will always protect Mr. Trump. You wrote that, right?
I did.
Now, when you wrote that, do you recall sending that statement out to a ton of reporters?
I sure did.
And you followed up that statement by sending it to them. You followed up with some communication with them, making it clear that you believed and you felt strongly that that statement was completely true, right?
I was validating the statement that I had sent out with that paragraph.
When you say that you were validating it, I mean, you were telling the reporters that what you wrote was true.
I wanted them to believe it was true, yeah.
So did you call them and say, I want you to believe this is true?
No, sir.
Or did you call them and say, it is true?
I called and told them this is true.
And you also, again, and this is again in February of 2018, you recorded yourself talking to reporters, telling them that your statement was true, right? Among other things.
Amongst other things, right?
And you did that. You even said, and correct me if I'm wrong, to one reporter, they had to believe you that you are a really bad liar. You said that, right?
I believe so, yes.
But the testimony in this trial is that you were lying to them when you told them that, right?
Yes, sir.
And you recorded them at that time in 2018 for what reason?
I don't recall. I don't recall why I recorded it. Maybe it was a different part of the conversation.
So it may have been for some other reason other than what we're talking about on the screen and what you were talking about as far as trying to validate your statement.
Yes, sir.
And that statement, by the way, was approved by your lawyers at the time, McDermott, Will, and Emery. Is that right?
That's correct.
And they were the ones that wrote the letter, which is 2018, correct?
Yes.
So, and you worked with them to make sure that the statement was truthful, correct?
I did.
And you worked with them to make sure the letter was truthful, correct?
I worked with them to put this letter out, which, again, I have characterized as deceptive.
I understand your characterization of it. But the reality is we just read it. Nothing in that letter is not the truth, correct?
Correct.
So, but is it your testimony that you were lying to your lawyers, to the McDermott lawyers?
No, sir.
I'm going to object here, Judge.
Sustained.
I'm going to move to another area.
Why don't we stop at this point? All right. Jurors, I know that we were going to stop today by 4 o'clock, so we are going to stop now. Before I excuse you, I ask you to please not talk either among yourselves. Sorry, I lost you there, Joe.
That's all right.
Either among yourselves or with anyone else about anything related to the case. Please continue to keep an open mind. Do not form or express an opinion about the defendant's guilt or innocence until all the evidence is in. And I have given you my final instructions on the law, and I have directed you to begin your deliberations. Do not request, accept, agree to accept, or discuss with any person the receipt or acceptance of any payment or benefit in return for supplying any information concerning the trial. Report directly to me any incident within your knowledge involving an attempt by any person improperly to influence you or any members of the jury. Do not visit or view any of the locations discussed in the testimony, and do not use any program or electronic device to search for and view any location discussed in the testimony. Do not read, view, or listen to any accounts or discussions of case, and that includes the reading or the listening to the reading of any transcripts of the trial or the
No
reading
listening to good logic.
or the reading of posts
Yeah.
on any court site. Do not
All right.
attempt.
All right, I just want to skip down if there's
Yep.
discussion between the parties at this point, because there's like still like 15 pages left here. So like this is just the jury exiting, and this is standard stuff. And let's get back to you here, okay?
Mr. Blanche, we had spoken about using this time to address some issues that you wanted to take up. Well-
Yes, Your Honor.
Yes, please proceed.
I will turn it over to my colleague.
Okay.
You can play Mr. Bro also.
Thank you, Judge. What we're hoping to address is the potential testimony of the expert that's been discussed in the motions in limine, Brad Smith, regarding campaign finance laws. And Your Honor set forth in your ruling on that motion a series of categories that you would accept or allow testimony from Mr. Smith on. And the one we wanted to discuss, the category that we wanted to discuss, is general definitions in terms that relate directly to this case, such as campaign contributions. I think just to frame the conversation, what has changed since the time of the ruling is that both parties have put in requested jury instructions, and both parties are seeking instructions regarding FICA and some of the definitions at issue. So one of the reasons that we wanted to bring this up before bringing the expert in is to give Your Honor a sense of what we would be seeking to do and to make sure that we're not encroaching on Your Honor's potential legal instructions. You have at once both parties were asking the court, I think, for instructions on a similar area. And we just want to make sure that the court is still contemplating what I think is a setup of as sort of a battle of the experts in some of these issues.
That's fine. You understand at this point, those are just requests. I haven't ruled on either request.
Of course, Judge, and that's why we wanted to flag this. And if I could, I would proffer the scope of what we would be seeking to do through Mr. Smith.
Sure.
So what we'd like to do is touch upon basic statutory definitions, and I will discuss those more specifically. And then there are phrases within those definitions that we think it's important that one way or another the jury gets some guidance on, whether that is through the competing experts that have been noticed or Your Honor. I can talk about the ones that we're focused on. One of them is the meaning of the phrase, for the purpose of influencing an election for federal office. The meaning of that.
Just give me 1 second.
Yeah.
Can you repeat that again?
The phrase, for the purpose of influencing an election for a federal office. And that's a statutory phrase. And then both parties have requested instructions regarding what I'll describe as the irrespective rule. And that's from the FEC's regulations. And then the third issue is the press exemptions, where we've requested an instruction. I don't think there's a competing request, and we would be seeking to elicit testimony regarding that exemption from Mr. Smith. So for basic definitions, I think Your Honor has in the parties' proposals contribution, relative individual contribution limits, the term expenditure, and the term coordinated expenditure are, I think, what would be the focus. And within a couple of those definitions, the statute lays out the phrase for the purpose of influencing an election. So that's why we would seek to elicit from Mr. Smith an interpretation of what that phrase means. And really what we would be seeking to do through him, Judge, is sort of track what is in the request that we've submitted to Your Honor. So by tracking that phrase is giving content by the Supreme Court's decision in Buckley that the test is an objective one under the D.C. Circuit's ruling in Orlowski. We would seek to have Mr. Smith describe the facts of Orlowski as a little bit so that the jury can understand what it means to have an objective test for the concept of the purpose of influencing an election. And then you're relating to the Congressman Jim Moran's 5141 that's cited in our papers. Again, describing some facts to give the jury a sense of a situation where the FEC has applied that term and how they've done it. Then the irrespective rule.
You're referring to past decisions and or hypotheticals.
Not hypotheticals, Judge. Just the past decisions that are cited in our requested charge. So that's for the purpose of influencing the election. Next, I mentioned the irrespective rule, which is set out in the FEC's regulations and cited, I think, by both parties in the requested charge. It's at 11 CFR 113, I'm sorry, 0.1G. And so we seek to have Mr. Smith discuss that rule and discuss the focus on whether an expense would exist irrespective of the candidate's campaign, which we think is an important issue for the jury to consider with respect to whether the payments at issue could be considered expenditures and or contributions. And then talk a little bit about how the regulation was developed beginning in 1995. We've cited for Your Honor our request that the Federal Register provisions that discuss the FEC's thinking about that. And again, through Mr. Smith, what we're doing is trying to give the jury a sense of what the requirements are for this term and how the FEC has applied them. And so we would walk through a couple more of the MURs that are cited in our request, 7025, 4944. And there's an advisory opinion we cite from 203. Not hypothetical, but just seeking again to give the jury a sense of applications and how the agency then administers the regulation that it created and applies it in practice. And then the last issue I mentioned that we would be seeking to cover with Mr. Smith is the press exemptions. And that sort of has a basis in both the statute as well as the FEC's regulations. And we've also cited an advisory opinion in our requested charge that alternatively we would have Mr. Smith describe again, just to give the jury a little bit of content around these terms. And I say that and make this whole proffer with a little bit of concern that we don't want to be treading on Your Honor's legal instructions. These are things that coming into trial based on the in limine ruling we had hoped to do through Mr. Smith. So now you have these two competing jury instructions and there's a little bit of tension here. So we wanted to
So you believe that the biggest impetus to this is to ask this court about, to argue that we now have two competing instructions, not the facts of the case, or that the testimony has changed, just the request for the instructions?
The reason that I'm making the proffer, Your Honor, is the instructions had not come in the way that they had, meaning that if the parties were not in agreement, at least with respect to the question, or should the court give instructions about FICA in these terms, we think we understand what Your Honor's in limine ruling says, and we were going to abide by that through Mr. Smith. We are now making this proffer to Your Honor so that everybody sort of has eyes wide open coming into Monday, when I think it's very possible this testimony could come in. That there's a little bit of tension right now between the pending request and what we would cover through Mr. Smith. We're sensitive to that, and we don't want to have him up on the stand and give the impression that we're encroaching on Your Honor's province.
Thank you.
Let me step in for Colangelo in the DA here. Your Honor, I think 95% of the proffered testimony that was just described flies directly in the face of your extremely clear March 18th order, which expressly said that Mr. Smith may not testify regarding the interpretation and application of federal campaign finance laws. You specifically held that he could identify general definitions, but not interpretation or application. So as to how each of these three terms of art in the federal campaign finance law that Mr. Bove just described, for the purpose of influencing, irrespective of the candidacy and press exemption, I think he just walked Your Honor through a very long list of federal case law, Supreme Court and D.C. Circuit case law, as well as agency advisory opinions and agency adjudications interpreting those terms. That is, that kind of testimony from an expert is precisely the reason that there's a general and broadly followed prohibition on testimony by an expert witness on legal matters. And Your Honor, I think there are two compounding problems here. One is that, as Mr. Bove noted, we have also retained an expert witness who, if necessary, would be prepared to testify as the same issues. But then we anticipate that he would say, based on what we've seen in the defendant's briefing, that the way the defense is interpreting the application of those statutes is inconsistent with how the agency and how federal courts have done the same. But then we've got three people telling the jury what the law is, when there should be only one. It should be Your Honor exclusively instructing the jury on how the law applies. I mean, by analogy, this would be like calling an expert witness to opine on whether the intent to defraud in the penal law definition does or does not, is or is not limited to pecuniary financial motive only. That's a brief. We've briefed it. It's identified in the charge. Your Honor has ruled on it, and that should be the end of it. In fact, the very fact that this is a contested legal issue in the party's proposed instructions to the jury is even more reason why this should be resolved through argument before Your Honor at a pre-charge conference, not something that we should be putting in expert testimony to discuss. I think there are two other problems. First, and unless I'm missing it, somewhere the possibility of any testimony on the press exemption has never been included in any of the defense's disclosures regarding this witness, either before or after Your Honor's motion in limine. So there's a serious notice problem with the press exemption proposal from the outset. And then there's a broader notice problem, Your Honor, which is that it's, as you know, dating back to last November, we tried for months to compel the defendant to disclose reciprocal discovery, including this expert testimony. We had to move this court to compel reciprocal discovery in November. Your Honor granted that motion. We didn't get the defense expert disclosure until January. And then the entire point of pretrial notice of proffered expert testimony is so the parties can prepare. We filed a motion limited to exclude the expert testimony. Your Honor largely granted it, and we prepared a potential rebuttal witness based on the language in Your Honor's the court's March 18th order. So to expand Mr. Smith's testimony at this point, just a few days before he may take the stand, presents a significant notice problem as well, because our witness, in reliance on the court's order, we have not prepared him to talk about the facts about a D.C. Circuit case or the Orlovsky case or the Buckley versus the Vallejo Supreme Court decision or how it applies. So, Your Honor, what Mr. Bove just described is totally outside and way beyond both what Your Honor already ruled and any recognized exceptions to the general prohibition on legal testimony from an expert.
We're not seeking to have three people at this trial instruct the jury about these issues, Judge. And that's exactly why I'm raising this. Why we're raising this right now, which is that the changed circumstance from our perspective is, I don't think there was, to our understanding, there was not an agreement prior to the start of this trial that Your Honor would provide instructions to the jury regarding these issues. And as you noted, it's still not clear that the court will. Judge, as a matter of just basic fairness, Given the way the people have now structured their theory of the case, the jury has to be provided instructions one way or another, or I will say information one way or another about how to apply these principles. And so what I've proffered is, from our standpoint, what I think are the very basics and the bare minimum that would be required for the jury to make an analysis of whether any of these things are unlawful contributions, which is a necessary showing here, at least that there was a conspiracy with that intent. I think we've been clear in pretrial motion practice, and from the start, we don't think that this jury here should be evaluating a FICA violation. We understand that before Your Honor, we've lost that fight. What we're saying now is that just basic fairness requires that they understand that what the principles are in a fair way. And I think on the press exemption question in particular, I don't think there could be any reasonable dispute that was absolutely essential to both AMI's defense and the FEC's analysis of whether or not there was a campaign contribution, both in the non-prosecution agreement and in the conciliation agreement. And so,
People, anything else?
Yes, Your Honor. Just 2 quick points and one to correct the record. My recollection is that Ms. Nescheles said to Your Honor at a bench conference last week, before any of the proposed jury instructions were in, that they intended to raise with Your Honor to question what their expert would be permitted to testify to. So I'm not sure that we can credit the characterization of this proffer and these instructions are necessitated by differences of opinion regarding the law and the proposed jury instructions. And then, second, on the press exemption, as you know, Your Honor, we haven't yet responded to the submission that the defense put in the other day. I'm not sure, as I stand here right now, that we will oppose the exclusion of the language in the charge to define the press exemption. But the press exemption is why this entire undertaking is way beyond what any witness should testify to. The statutes and the regulations combined contain about 20 words of text on the press exemption. The entire concept is developed almost entirely through additional case law in courts and through agency application. So it's exactly the kind of thing that has been developed through the adjudicative and agency determination process, and that the parties can discuss with you, and that you should decide, Your Honor, not an expert, certainly not competing experts instructing the jury.
All right. Thank you. Mr. Blanche, just give me a second, all right?
yes, Your Honor.
I don't think that the fact that each of you has submitted proposed jury changes necessarily changes my ruling or my decision to the motions in limine. To direct your attention specifically to the area that dealt with this, I direct your attention to pages 1, 2, and 3 of the court's decision. And I will read from the very next to last paragraph of the court's decision. The people's motion is granted to the extent that Smith may not testify as a lay fact witness, offer opinion testimony regarding the interpretation and application of federal campaign finance laws and how they relate to the facts in the instant matter, nor may Smith testify or offer an opinion as to whether the alleged conduct in this case does or does not constitute a violation of the Federal Election Campaign Act. However, Smith will be permitted to testify generally as to the following: general background as to what the Federal Election Campaign Commission is, background as to who makes up the FEC, what the FEC's function is, what laws, if any, the FEC is responsible for enforcing, and general definitions and terms that relate directly to this case, as such, for example, campaign contribution. As I listened to your presentation, Mr. Bove, it sounds to me like what you are asking is that I enlarge this decision quite a bit. When I hear you use words like interpretation, past decisions, advisory opinions, that does sound an awful lot like what would normally be called opinions on the law. And in fact, you use the term a battle of the experts. The only reason we would get into a battle of the experts is if your expert got on the stand and testified as to some sort of expert opinion, not only about FICA, but possibly the law, and then the people would put on their expert to rebut that. And then I would have to instruct the jury. We are definitely not going to go there. What I'm going to do, in fairness to you, because I would like to digest both submissions further, I will take some time this weekend to do that, to read and study both sets of submissions. I would like also to read the minutes from what has just happened here. But until you hear differently from me, my ruling has not changed. It's going to be limited to very, very general definitions and very general background information. I also do agree with the people that they had asked for a very long period of time for disclosure and notice regarding the expert witness. And despite the repeated efforts to get that, it didn't come until finally, very late in the game. It was offered, but in a manner to suggest that the witness would actually testify as a fact witness. And you know what my ruling was on that. An expert can't testify as a fact witness because they don't know the facts of the case. So at that point, the purpose of your expert was greatly diminished. Again, in fairness to you, I will consider your arguments. I will go back and reread the submissions, but until and unless you hear differently from me, my ruling has not changed. If there is any question to what the ruling is again, go back to pages 1, 2, and 3.
Thank you, Judge. That's understood.
Sure. What else? Nothing else from either side?
Nope.
Let's talk schedule. As we discussed a little bit, I'm doing everything possible to avoid big breaks between summations, jury charge, jury instructions, and deliberations. I will try not to break up summations, if at all possible. As we discussed in the rubbing room, the deliberations should follow immediately after the jury charge. It's not ideal for there to be a big lapse in time between summations and the jury charge. So I'm trying to avoid that to the extent that I'm able. If you asked me if we could possibly start early, you asked me if we could possibly start early. I'm going to look into that and see if we could start early. I think that we can work a little bit late on some days, but unfortunately we can't work on Wednesday. As of right now, we know that one of the alternates can only work until 1 on Thursday. I don't think that's going to be a problem one way or the other. We will play it by ear and see how that plays out. How much more do you think you have of Mr. Cohen?
I think not a lot. I think I'll be finished with Cross Monday before the morning break.
All right. Any sense of how long the redirect might be?
Tricky.
Sorry, I got kicked out, and so I'm behind now.
Okay.
Where am I at?
Don't worry about it.
No, I would say under an hour, Your Honor.
No, I would say under an hour, Your Honor.
Okay. At this point, do you expect to call any other witnesses on the direct case?
No, Judge.
Other than the expert witness that we just discussed at this point, do you expect to present a defense case?
We anticipate reaching a decision, at least with respect to any potential rebuttal witness, very soon, like today. And we'll communicate that to the people and including the court. If we do have any rebuttal witnesses, we do not anticipate that they will be long, at least on direct. I don't think it's necessarily, well, I don't want to make commitments about the day on Monday, but it's certainly reasonable to believe that if aside from Mr. Smith, that the witnesses will be able to get on and off on Monday.
And when you say rebuttal witnesses, are you referring to the witnesses that we spoke about earlier today or something else?
The witnesses that we spoke about earlier.
All right. It sounds like we might possibly be done with the presentation of evidence on Monday.
I was not speaking about President Trump, obviously.
Right.
So that's another decision that we need to think through.
Right. There's a possibility that we will be done with the presentation of evidence on Monday. And if that happens, we will have our pre-charge conference on Monday. Please be prepared to begin summations on Tuesday if we do wrap it up on Monday. Of course, you will see my instructions before you deliver your summations. I will get them to you with as much notice as I can, probably get them to you. I will make every effort to get both summations in one day. That means working early and late. Working early/working late. If push comes to shove, I might have to break one of the summations over to the next day, which I hate to do. Anything else as far as scheduling? I am open to your suggestions. All right. Thank you.
Thank you.
Thank you, Your Honor.
Well, there you go. So, what do you make out of that whole? You make anything out of that, Ron? From that whole dialogue, as far as on the expert witness there at the end.
I'm not really familiar with the original ruling, but frankly, my green screen. Frankly, the judge strikes me as correct.
Right. Yeah. Normally, when it comes to expert witnesses, they're not supposed to be telling you how what the law is. That's for the judge to do. I mean, it's not what it did seem as if what Bove was asking the court to do was expansive on what the judge issued. The ruling the judge issued is fairly common, because you don't want to have someone come in there and say Trump wins or a prosecution wins. You don't, because the law is this.
Also,
So that's
right.
Yeah.
And the only person who's supposed to tell the jury what the law is the judge.
right. So that's why
I guess I kind of understand what it is that they're even bringing this guy in for, and I kind of don't. Like, they read through what it all was, but I don't know. Like,
I have the same questions. Like, what's the utility of this guy at this point? So he's going to come in there and say, I mean, if what's going to talk, what can he say that will make him more likely to think that Trump is in this very narrow field that he's allowed to talk about, to make them feel that Trump should be found not guilty? It's kind of difficult for us to know until he actually comes in. And in other words, as Ron is apt to say, you only know how to strategize a case if you have the red well. You don't know anything if you don't have the red well. So why it is that what nugget or 2 or 3 that they're hoping to get out of him, it's very difficult for us to speculate at this point. Only once he gets in there can we sort of try to assess what they were hoping, or what they are hoping that the jury will take from it that will benefit Trump. But at this juncture, it's a little premature for I, or probably Ron, to try and weigh in on that.
Especially Ron, because of his relationship with the Trump campaign.
Yeah.
I wouldn't reading the script is all in good fun, but any kind of opinion on this, I would be a little bit reluctant to express.
Let me hit a couple of chats here. Doolin Dolan, thank you for the very generous $20 tip that you threw at me, and also hitting 10 Good Logic memberships. That's right, 10 Good Logic memberships. We're not going to go through the whole shebang there because, well, I think most of you all probably heard it. But long live Liberty, Robert Catlett, LB, Vanilla Gorilla, Dragon Book, Serenity, Ryan, Kevin Kivinus, and Two's Ret, Barb Belmont, all of them gifted memberships courtesy of Doolin Dalton. God bless you, Doolin Dalton, bringing on in the members of the following. The following is about personal growth, community, unity, some leadership training. It is not at all a type of cult. And yeah, if you want to know who the leader of the following is, I can reveal now. It is Ron Coleman. So
all hail Ron Coleman!
All hail Ron Coleman.
Oh, hail Ron Coleman.
If they convict him, does Trump win in a landslide? What are your thoughts on that, Ronald? If he gets convicted, do you think that he wins in a landslide?
Let's talk about the rules of evidence.
All right. If you enjoy this content, do the free stuff by liking and sharing the stream. Thank you so much. Remember, you know what? I'm gonna give my mod here over here. I'm gonna give him a horn for Chris Rowland. Please make sure you like and share the screen. Remember to switch to live chat. Beware the Penguins. They are growing. This is true. This is an indisputable fact that the Penguins are indeed growing. Just doing a double check over here on Rumble before I make sure that I didn't miss nothing there. I think I'm good there. I'm good over on Locals. I urge you to check out goodlogic.locals.com. That's goodlogic.locals.com. I want to thank each of my players for the phenomenal read we had tonight. You guys were exceptional.
Great fun.
Thank you, Joe.
Each and every one of you were really great in your specific roles. And I look forward to being back here tomorrow evening. I'm going to try and do a local stream tomorrow at goodlogic.locals.com. I'm going to try to do something for you guys tomorrow, give you perhaps some updates on my whole ungag Trump thing and a letter that I'm in the middle of kicking out to the court and responding to stuff that happened with the ADA, where the ADA is trying to bounce us out based on the decision that was issued against Trump and use that decision against us. And our response to that, which I will share with you tomorrow on Locals. That's at goodlogic.locals.com. If you want to help support givesendgo.com/ungagtrump. We would be much obliged, as we're probably, almost certainly going to have to try and get before the Supreme Court to get the relief that we're looking for. Thank you all for joining me. You guys are awesome. Every one of you, no matter what you do, sometimes you have challenging decisions in life. I understand that. One decision that should always be very, very simple for you is no matter how they sell it, how they package it, how they brand it, don't eat the bugs. Have a good night. And as always, Godspeed.
Good night.